Ms. Wilbur, you can go ahead, just push the little person on the mic machine and you should be able to go.
Thank you. My name is Monica Wilbur. I represent Higher Ground, which is challenging the Utah State Board of Education's Board Rule R277-700-74 on the grounds that it violates conscience and religious belief, which are essential to freedom. Utah's faith-based founding saw this area settled by Mormon pioneers fleeing from religious persecution. Today, Utah is home to many religions. 73% of Utahns are Christians. Jews, Muslims, and other faiths comprise another 7% of the population. This means close to 80% of Utahns profess religious belief. Conscience is universal. Our Creator has given everyone a conscience, even if some would have us ignore that fact. So let's increase the number of people impacted by the rights of conscience and religious belief to 100%. And of course, that includes the children in our public schools. Children do not check their consciences at the school doors. Our Utah Constitution is unequivocal on the special protections that the rights of conscience and religious belief merit from the state. In Article 1, Section 4, it states that the rights of conscience shall never be infringed. And in Article 3, it states that perfect toleration of religious sentiment is guaranteed, and that the state shall establish a system of public schools free from sectarian control. The word sectarian isn't applied exclusively to religion, and also applies to secular instruction that is biased, intolerant, and doesn't allow for deviation. HB 348 was a bill that strengthened a student's right to not participate in any aspect of school that violated a right of conscience or religious belief. It passed with a legislative supermajority in 2023. It realigned state law 53G 10205 with the state constitution. It established that a school cannot punish or discriminate against a student for refraining from participating in a violation of his or her own conscience, and that a school cannot override a student's conscience. This last point is important because the board just amended a rule to require a student to master core standards for graduation, even if those very core standards are what violates a student's conscience or religious belief. R277-700, as amended, infringes on conscience, law, and the Constitution. First, it must be very clear that the USBE had no authority or expertise to amend R277-700 in the way they did. The board's own legal policy advisor said in 2019 that the board needed to repeal the previous rule it had made for 53G 10205 on constitutional issues in schools. Let's watch the video.
We'll move on to 7.5, which is R277-105.
Just a quick background on this. In speaking to Assistant Attorney General Buse on this rule was originally written to give guidance to some of the smaller LEAs on what some of the requirements are under the Constitution for free speech and student rights under the Constitution. The requirements set forth in this rule are all spelled out in the Constitution and in case law that's been set forth, and it's really not something that's the board's authority to create these requirements or not create these requirements. The rule isn't necessary to protect these rights. They're in other statutes and in the Constitution is the feeling there. Generally, we try not to repeat what the law is in other places in board rule, and so for this reason, in consultation with the AGs, we're recommending that the board repeal R277-105.
Given this confession, it's a mystery why this board was even allowed to amend R277-700 as it did, since it now creates requirements and interprets student constitutional rights, the very thing the board's legal counsel said the board didn't have the authority or the expertise to do and rule. The Law and Licensing Committee was told this in June when USBE staff wrote another rule to substantially reinterpret and infringe on 53G 10205. That rule was stopped in its tracks, but just 2 months later, members of the Law and Licensing Committee returned with amendments to R277-700 that did the very thing they had already been informed that they have no authority or expertise to do, which was to interpret how schools should handle student constitutional rights. This fact alone is enough to disqualify the board's R277-700 amendment. Now, let's move to the second reason this amendment is unconstitutional. Second, the board's R277-700 amendment continues to infringe on conscience, law, and the Constitution by telling schools they can only honor a claim on conscience if it can be reasonably accommodated according to the conditions listed in the definitions that apply to all the parental rights law. Under this law, a school need only accommodate conscience if 14 different conditions are all met. You can see them on the screen. Those conditions include balancing the educational needs of other students, teacher workload, the efficient operation of the school, etc., etc. There isn't a single claim of conscience or religious belief that couldn't be overridden by the state, thanks to this provision in Parental Rights Code. Parents are being played if they think reasonable accommodations means the schools are accommodating them. Having to meet all of these conditions to honor student conscience puts R277-700 in a direct collision course with the law that it illegally regulates, 53G 10205. Rights of conscience and religious belief are sincerely held and aren't mere preferences. Some are using what-if hypotheticals to discourage students from even exercising their consciences to begin with. What if a kid refrains from participating in math because math violates his conscience? An absurd claim like this has no standing because that's not conscience at this point, and the law provides for checks on frivolous claims. So, if a child says doing math on days that end in Y violates his religion, the law requires that the school contact a parent who can act as a check on the child. And on the crazy chance a parent says, yeah, that's Johnny's religion, I guess, the school need not recognize this far-fetched, insincere claim as conscience, as was confirmed in the case of Heart of Atlanta Motel. However, if the claim is a religious sentiment or inspired by a sincere and internal sense of right and wrong, schools must err on the side of conscience. Children who refrain from participating in their own indoctrination aren't disrupting or hurting anyone else. They are just protecting their own minds and hearts. Who could be against that? It's undeniable that ideologies are being taught as indisputable facts. For a school to force a student to affirm false ideas for a grade or graduation is not just wrong, it's unconstitutional. There is no state compelling interest state interest compelling enough to justify requiring students to violate their consciences or religious beliefs. Micromanaging children's consciences is an unjustifiable use of this board's time and resources, especially when student academic achievement is so low statewide. R277-700 did need to be amended, but only to be made consistent with the new conscience law. So Higher Ground recommends that the board adopt a simple amendment like the board staff draft 1. A student or parent may refrain from participation consistent with section 53G 10205. Rights of conscience and religious belief merit higher protections from the state. A bare desire for perfect uniformity in the application of a law cannot be an end in itself, or religious freedom as we know it is dead, and conscience killed with it. This board must avoid the arrogance of governance that fails to recognize that, quote, in the United States, the free exercise of religion is not a mere policy preference to be traded against other policy preferences. It is a fundamental right, end quote. Whether it's graduation or grading policies, you'd have a hard time convincing a judge that any of these are so compelling as to justify taking precedence over constitutional rights. Children do not check their consciences at the school door. R277-700 as amended can deny a student the benefit of graduating if a student refrains from mastering a graduation requirement that itself may be the source of a violation of conscience or religious belief. Such a denial is unconstitutional, as in the case of Trinity Lutheran, quote, "The government imposes a substantial burden when it withholds a public benefit because of religious belief, practice, or identity," end quote. Graduation is one such benefit that cannot be withheld. It is this board's sworn constitutional duty to fully uphold the rights of conscience and religious belief in the public square we call school. Conscience and religious belief apply to and protect 100% of all students. To amend these rights to be anything less is educational malpractice, which can't be committed without a reckoning. Thank you very much.